All right, let's get right into it. There's this major new standard for tiny houses called ICC 1215. Now, on the surface, it's supposed to make everything simpler for builders and for people buying them. But, as we're about to see, there's a pretty serious legal fight brewing just beneath the surface, and it calls the whole standard into question.
And that brings us to the big question, the one at the heart of all this. Could these new rules, which were designed to help the tiny home industry, actually be breaking federal law? It's a complicated question, and the answer seems to be buried in a paper trail that's, well, a little incomplete.
So here's where the problem starts. It's basically a collision of two different worlds. In one corner, you have ICC 1215, this brand new building standard for tiny houses. And in the other, you've got federal law from the U.S. Department of Transportation, which has been regulating motor vehicles for a very long time. When these two overlap, you get a whole lot of confusion and potential legal trouble for everyone involved.
And here's the crucial point. The complaint isn't just that these two things overlap. The real accusation is that this new standard actively creates an obstacle. The claim is that it basically carves out a whole new path to get around existing federal rules, creating a direct conflict with what Congress intended.
Okay, now this is where the story gets really interesting. A formal complaint about this whole federal conflict was filed. But when you go and look at the public record of this complaint, key parts of it are just gone. They're missing.
So let's look at what's not there. You can't see the original complaint that raised the alarm. You can't see the evidence that was submitted with it. You can't even see the author's response to the official reply. And maybe most importantly, there's no paper trail showing how the committee actually analyzed and dealt with the complaint. All you can see is the final official response. It's like hearing only one side of a phone call.
And this quote just nails the problem. When you only publish the final answer, but hide the original question and all the follow-up arguments, there is no way for anyone on the outside to know if a fair process, due process, actually happened. You're basically just seeing the verdict without getting to see any of the trial.
And the takeaway here is pretty stark. The argument is that by hiding all of these documents, the problem wasn't actually solved. It was just concealed, pushed out of sight, leaving a potentially illegal standard out there for everyone to follow.
So to really get why this is such a big deal, we need to quickly crack the legal code on a concept that's at the very heart of this complaint. It's called federal preemption.
Okay, first up, preemption. The easiest way to think about this is like the ultimate trump card. The U.S. Constitution says that if a federal law clashes with a state, local, or even a private standard, federal law wins, every time. It's the supreme law of the land for things Congress decides to regulate, and that includes motor vehicle safety.
Now let's get a little more specific with obstacle preemption, because this is really what the complaint is all about. A local rule doesn't have to literally say ignore federal law to be illegal. If it just gets in the way, if it creates an obstacle that stops a federal law from working the way it's supposed to, it can be struck down.
And so what happens when a rule is preempted? Well, it becomes inoperable. That's the legal way of saying it's void. It has zero legal force. It can't be enforced. It's basically a dead letter, no matter where it's written down.
All right, so now that we've got those legal terms down, let's circle back and see how they all add up to this core accusation, that this tiny house standard created a deliberate detour around federal law.
Here's how it's laid out. Federal law has a very clear lane for anything that's a motor vehicle, and it has a long-established process for compliance through the Department of Transportation. The accusation here is that the ICC standard basically tried to create a new lane by inventing a new term, the small residential unit, and then building its own separate off-ramp for compliance, letting builders bypass the federal highway entirely.
And as this quote says, you can't just nullify federal law by slapping a new label on something, right? You can't call a car a personal mobility pod and then argue it doesn't need to follow traffic laws. The argument here is the exact same thing. Changing the name doesn't change what it is, and it definitely doesn't change the laws that apply to it.
So why should any of us care about a fight over some legal definitions and committee meeting notes? Well, because this goes way beyond just tiny houses. This is about the integrity of the whole system that creates the rules that are supposed to keep all of us safe. So let's just walk through the alleged failure of the process one more time. Step 1. A really serious complaint gets filed. Step 2. The most important documents, the complaint itself and all its evidence, are kept from the public. Step 3. Only the official answer is published, which tells just one side of the story. The result?
a process that pretty much prevents anyone from the outside from reviewing what happened, and in doing so, buries a huge potential legal conflict.
And that really gets to the heart of it. This whole debate isn't just for lawyers or tiny home builders. It raises a huge question for all of us. How can we trust the systems that write our safety standards if they aren't totally transparent and accountable to the public? Because you can't have real accountability without a complete record of what happened.
And that leaves us with this final thought to chew on. When a process that's supposed to be about protecting the public seems to rely on hiding information, who is it really protecting, the public or itself?